rules, legislation and regulations, or policies and instructions. Is that right?
Correct, Chairperson. We always make recommendations to relevant accounting officers to take actions against those people.
So you are not the ones who take action against them. You only make recommendations.
Yes.
Do you have statistics that could tell us how often your recommendations are complied with, generally?
Chairperson, we don't keep stats, but at least we do have cases, that we can provide and say these are the recommendations that were made to relevant accounting officers to take action against but perhaps that would be what we have as statistics. But as to whether the officials do comply in those things, I think there's definitely a gap there. But what I do know, because the work that we do to a greater extent also involves the Auditor General, although the Auditor General's work is post facto. So we cannot track whether our recommendations are actually implemented.
So your office or Treasury, National Treasury, as far as you know, will not have statistics as to how often various government departments and maybe state entities comply with recommendations for action that your office may be making or may have made over the years.
Thank you, Chairperson. I think on a very small scale, we do have stats, but not to the extent that we would have loved to. I do know that in terms of recommendations where, for instance, we get applications for condonements of instances where processes were not followed by officials, that we do require certain information on the basis of which a decision should be made on whether or not to approve condonements for irregular expenditure. We do have that stats, but on a broader scale, no, I think I must just admit that we don't have that stats, but we do have, especially for those national departments, I would suppose, and to some degree provincial departments, but surely at local government, we don't have that stat.
Do you know whether within government there is any office that could give this commission that kind of picture nationally, in terms of saying there are a lot of irregularities that are connected with procurement throughout government, and that government is determined that there should be consequences for these things, for non-compliance, and therefore it is monitoring whether action is taken when officials employees of government and even accounting officers themselves have not complied with procurement rules, policies, and legislation, so that nobody thinks they can continue with non-compliance because there are no consequences.
Thanks, Chair. Yes, there is an office. The Public Service Commission, in my understanding, can provide that kind of information because in many instances, some of these are reported to the Public Service Commission, and I do know, as a matter of fact, that the Public Service Commission is quite efficient, and they do make follow-ups on those allegations, and they also do make follow-up in terms of whether accounting officers do take actions as recommended by the Public Service Commission. But they are that kind of office which the Commission could approach to get such statistics. As indicated, I'm sure to a limited degree, the treasuries also could provide such information, but more in the office of the Accountant General within Treasury, at least National Treasury, we could have such information because I do know that they do make follow-ups on some of these issues, and of course other law enforcement agencies. But the Public Service Commission is the office that consolidates such information, and I'm sure they could be approached in this regard.
As far as you understand the Public Service Commission, when it has received such reports from government departments, what is it supposed to do? Is it just for statistics, or is it just to make further recommendations to ministers, premiers, or what does it do with those reports once reports have been made to it?
Yeah. The Chair, as far, now I'm speaking under correction, but I do know that they act on those reports. They follow up with the relevant officers and also political leaders, office bearers, to make sure that action gets taken against those reports. It definitely does. That office does make a follow-up on what eventually happens. Why I'm saying so, I have to state this because allegations are made on a number of cases, and then even to ourselves, the Treasury, investigations are done on individuals where allegations are made. But of course, the Commission always wants to know what action has been taken. So they present this to accounting officers, and they also demand the reports of what exactly transpired in terms of enforcing the recommendations of the Public Service Commission.
Okay. And then in terms of non-compliances that come to your attention that you are able to do something about, because I think you did give evidence that when you become aware of allegations of irregularities, you follow those up. Now, do you follow them up only if there is a formal complaint, or do you follow them up, for example, even if you were to read in a newspaper that there are complaints of irregularities in regard to a certain tender, do you follow them up, or do you have to have a formal complaint lodged by somebody?
We actually do both. Because our position is that the public is actually a guardian of or at least they should be seen to be contributing to guarding against irregular practices in the procurement space. So whether we read in the newspapers that there are certain things happening in a particular public entity or government department, we are quick to demand documentation that, of course, pertains to that particular allegation, in as much as we receive formal requests. At times we get information, at times we battle to get information for our own investigation. But we act on both. We read, please give us documents. This is what we read in the media. We want to know exactly what happened, and we do our own assessment, that's one. But also when you have formal, we get a lot of them. We get a lot of complaints, I mean, ranging from irregular practices up to the non-payment of suppliers on time, which is a challenge currently in the country, and we intervene where we can. But of course, we do work with also the DPME, Department of Monitoring and Evaluation, in this regard. But we act on all these instances to find out exactly, because we can't take these things for granted. I mean, that's exactly what is happening currently.
And with regard to the decision making in regard to tenders, you talked about, I think, the first instance committee. Is it the bid committee, bid adjudication committee? Is that what it's called?
Yes.
Yes, and you said that part of the reason why that committee is critical is because that's where it looks at the specifications, for example. Is that right?
Yes.
And you said that you could have situations where specifications are formulated in a certain way in order to favor a particular entity that will later on tender. Yes. Now, the actual adjudications of tenders, they are done privately, in the sense of not in public. People sit in some boardroom and decide them. Is that right?
Yes.
Now, generally the public will just hear that a particular tender has been awarded to a particular entity, but they won't have any participation of any kind. Is that right?
It's correct, Chair.
And that process of adjudication is not transparent. Is that right?
It is correct, Chair, in the sense that it is not open to the public at large.
Yes.
And it doesn't, of course, involve members of the public.
And the people who make decisions on tenders don't provide reasons until there is a court case. Is that right? Or do they?
There is what we call, Chairperson, in the process debriefing. And I do know that some institutions do conduct debriefings because it gets provided for, if it is provided for in the tender document. But the information is also made available on application, whether through PAJA or through PAIA. That information is actually made available. But in certain instances, I am aware, because I also chaired a bid adjudication committee for more than 10 years. on transversal contracts as a chairperson and also head of that office. I do know that at times the losing bidders would, without thinking twice, resort to the court process and apply court processes to request records and so on. And we make a record available, of course, that's what our duty is. And of course, relying on the fact that if the process was transparent or is transparent, then there is no reason to fear to disclose the document, unless, of course, one is hiding something out of this process.
You see, I'm thinking about that because I think it's important that we look at what it is within the procurement system that is weak, which results in the levels of corruption and irregularities that are associated with procurement in the country. Because my observation is that a lot of corruption, when we talk about corruption in this country, is connected with tenders. You see? So it's a very important part of what we must look at, because that's part of the terms of reference of the Commission. Part of the terms of reference, actually 1.5 and 1.9, says we must look at the extent or the nature and extent of corruption, and therefore we need to look at what are the systems that are in place. Are there weaknesses in the systems which encourage, in a way, or make it possible for corruption to go on at the rate at which it is going on? So the issue of transparency might be important, because if the losing bidder has been given reasons why he or she lost or it lost, that might go a long way to convincing them that there is no corruption in the decision. They lost because they deserved to lose. So it may well be that to the extent that the reasons are not provided as a matter of course, that maybe that should be considered. Do you have some comments on that as somebody who has been very involved in procurement? Is it something that you think might assist? Is it something that might be practical?
Thanks, Chair. But thank you very much. But I must also say that when we talk about the bid adjudication, we're talking about the last leg of the process. And I just want to reiterate that, yes, transparency can help to make sure that a number of people do take part. But at the same time, my own personal experience is that out of 100 bidders, one wins. The 99 that are losing would always cry foul, legitimately or illegitimately. So, but the issue is, if the adjudication process itself is opened and people can see transparently what is being done, whether losing bidders would actually say, no, now I'm happy and so on. But it is a good thing that we can always promote. Historically, Chairperson, If you take the construction sector, our prescripts make it mandatory to read the prices at the closing and opening of bids. So we read prices in the presence of those that the interested parties. But that is it. And in the mind of the bidders, they always say, look, my price was the lowest, and therefore I deserve to be awarded a tender. But when you look at the entire, because this entire process, I might be lower in price, but I've got a shovel and a spade, and therefore I can't build even a single house, or a shovel and a wheelbarrow. Hence my price is low. And somebody else who's a little bit higher in terms of price might be having the technical expertise to make sure that the building is completed. That's one part. But the second part is price is not always the sole determinant of a winning bidder. That's why we're speaking about a combination of the points, the preference points. So you take price, you take these other elements, and then you put together, then it determines who the highest scoring bidder is, provided that bidder complies with all specifications. But I think without discounting this proposal, it's something that we can take and test. I know that in Gauteng, in a few years ago, there was an open tender process that was introduced, but I haven't seen exactly, the impact thereof. Perhaps that's something that one has to do an assessment of what was the impact of that particular process, and then we can see whether we can roll it out throughout the whole procurement system in order to deal with the issue of transparency. But having said so, that the adjudication is the last leg, you also have this leg which is right at the beginning, where there's a potential of crafting the specifications to arrive at a particular outcome, which is also a bit of a problem, because I don't think that you can involve the public unless you inviting the experts to come in and sit in that process, as indicated in my earlier presentation.
Well, what do you think can be done to deal with that situation where corruption takes the form of somebody within a government department who knows an entity that is likely to tender in due course or that will tender, who then decides that the specification must be formulated in such a way that when the adjudication happens, only one bidder will succeed, in the sense that that one will fit into the specification perfectly. What should be done to deal with that situation?
Yeah. Chairperson, the current processes, if I may just take, all tenders are published. So every 1st of April, there are procurement plans that are sent to the National Treasury, and I suppose also to relevant treasuries, where planned tenders for a particular year are published, so that potential bidders can position themselves to know what is coming. And of course, that's the current system that we have. So it's available on our website. If everybody they can go in and see. That's one. But secondly, the results of all bids are also published, and reasons why some of the bidders have been successful and some not. But to answer your question directly, what should be done? Apart from enforcement, where as far as I'm concerned, accounting officers must be made to account, because they must make sure that the specifications are not biased, and they must also approve these specifications before they go out into the market, and they must ask questions, and serious questions where there is no clarity in terms of specifications that are supposed to go out. It's more making it a responsibility of accounting officers. Maybe one can even think about putting this into their performance agreements to say, when a tender goes out in your department, personally, accounting officers must make sure that they read these things, and where there are issues, they raise them before a tender gets put into the public domain. Because if you miss that step, and obviously you've missed the biggest part of the process. Because we prescribe that when evaluation is done, evaluation must be done in terms of the criteria published and nothing else. And also at adjudication stage, the adjudication committee must look at all these processes. This was the tender published, and this was the criteria specified, and this is what the BEC, the Bid Evaluation Committee, has considered during the evaluation, and therefore this is the outcome. And these committees as well must also ask questions. Now, depending on delegations, because some of the bid adjudication committees are delegated powers to make final decisions, but in many other government institutions, that final decision rests with accounting officers. So again, I think we are open to taking proposals of how we can strengthen that particular system to make sure that that whole chain. Otherwise, I don't even want to consider going back to the old order, the state tender board, where you have a board that has to look at this thing, because you might not necessarily do. But the other thing that we can do, which we always do, by the way, is to benchmark against systems of other countries. I know I've been to Ghana, and then looking at systems of various other African countries, including countries from the Caribbean, and in some cases from Europe, just to look at what is best practice, what do they do, to make sure that we deal with these issues of allegations of corruption in our processes and the fraud that exists.
What are the chances of somebody else detecting that there has been an unfair formulation of the specification once the person who has done that has done that? How easy is it for somebody else to say, but there's something wrong with this specification? Is that something that is easy to pick up, or not really? Or it depends on how bad the person is who was trying to formulate it in a certain way? If he's quite skillful, nobody will pick it up.
Yeah. Thanks, Chair. You raise a very important fact. Look, it depends on experience. Some of the officials can simply tell you right from the beginning that this tender is cooked. But it depends on how long have you been involved in the system to pick those things up. You can say even at adjudication, no, this specification was cooked, and because it was cooked in that way, and therefore this thing can't pass the test. And you refer it back Sorry to say, but I think I've detected, but like I'm saying, on a number of instances where I could see that no, this particular tender is cooked, and I simply return it back and simply not approve. But it's experience. I mean, this is a game of experience to understand, and also the application of all the policies that apply into the system. But not all of us, of course, are experienced.
Would there be somebody in any particular department or a state entity whose duty would entail precisely that, before a tender is finally adjudicated, to check whether everything has been done the right way, but also to examine the specifications and see whether they can pick up if it has been, as you put it, cooked, or check against the needs for this job and see whether the tender accurately reflects really what is needed. I mean, I'm just thinking that if I can make an example by way of appointing somebody to a position as opposed to appointing a supplier, appointing somebody to a position. If I have a particular position in the department and I know that I have got a friend who can do that job, but that job, really the person who must do that job doesn't need more than a bachelor's degree in that field. But because I know my friend has got a master's, then I say one of the requirements is that you must have a master's. Or if my friend has got a PhD, I say you must have a PhD. But actually, when somebody looks at what this person is supposed to do once appointed, they might be able to say, you actually don't need a PhD. A bachelor's degree is just good enough. So in other words, now taking that example to what we are talking about, would there be somebody who can look at all of those things?
Thanks, Chair. Correct. Many of these, especially at SOCs, they've got, or they're supposed to have compliance units. And then it becomes the responsibility of the compliance unit to make sure that the processes are beyond reproach and above board. But what we are proposing in the review, we are proposing something that we still need to discuss and agree on, is to extend.
I'm sorry. Mr. Bashe, you have been standing for a long time. Please feel free to, I didn't realize you were standing. Please feel free to sit, and when I'm done, you can rise again.
Thank you.
Okay,
thank you.
I'm sorry, I didn't see that.
Thanks, Chair. What I was saying, above just the compliance units, we are thinking whether it won't be possible to extend the mandate of internal audit function within departments, because all of them have got internal audits, to see if, given the capacity constraints that we have in the system, whether we can't use internal auditors to audit our procurement processes before they actually get finalized. Something that we're thinking about, and I think we will propose that also in the reforms that we're engaging in. Although we know that their function is mainly to help us in terms of regularity audits, not necessarily in terms of forensic and so on. But we're considering extending that particular mandate to say, give them a responsibility. They must vet all our processes and to make sure that they are beyond reproach before a final decision, and then give us a report, at least from an independent point of view, because we're not procurement. This is an independent, and I guess they subscribe to their own ethics. And in my view, this would be one of the instruments that we can use to make sure that before a tender is finalized, it gets subjected to internal audit for review. And then they can, of course, identify areas where there are concerns, and we can address these issues even before the award of tenders. That's just something that we're thinking about for now, Chairperson.
Well, that's I think that's quite important, because I was about to ask whether there is any internal process to say if a decision has been made before it's sent out to the bidders, or successful and unsuccessful, whether there is a process where people other than the ones who have made the decision can look at it and see whether everything seems to be fine. So from what you are telling me, it would appear that as things stand, there is no such process, but you are considering introducing a process that would run along those lines. Yeah. Yes. Okay. Now, have you got, or your office or treasury, any statistics as to what percentage of tenders, maybe provincially and nationally, or just nationally, really get contested compared to the total tenders that get awarded? In other words, what I read in the media, which gives me the impression that it's a lot of tenders that have got problems, to what extent is that a fair reflection of the position, or is that 10% of tenders nationally, for example? Is that 20%? In other words, we might be too concerned in circumstances where maybe it's just 1%. Not that we should not be concerned at all, but obviously if it's 1%, your degree of concern is not going to be the same as if it's 45% and more. Do you have statistics along those lines in your office or treasury? Does the treasury have, or anybody?
Thanks, Chair. Because procurement takes place at all institutions, and there are open tenders after a certain threshold. For instance, open competitive tenders, the threshold is 500,000 currently. So what you see contested in the main is what is above that threshold. Because below that threshold for national and provincial sphere of government, go through normal quotations where you get 3 codes and so on. And that's one process that we can't see. If you're talking at local government, the current threshold is 200,000. So now it's everything above 200,000 must be on an open competitive. Anything below that is of course, procured through quotations. And the thousands and thousands of transactions as we speak, as I sit here, that are happening in government. We do have a reporting system currently might not be perfect through the central supplier database. There is a reporting system where, transactions and contracts are reported, but that might not always be accurate. The only other stats that we use to determine how much goes through government is through another system where payment is done, because you need to pay at the end of the day. And at least that particular system will give you a much more accurate, may not be accurate, but accurate of what exactly is happening. But as to giving a split in terms of percentages it's a bit of a challenge for now. And Chairperson, can I also just go back to your question earlier around this internal audit? In our reforms, in the procurement bill, we are making provision for a procurement ombuds so that you give a cool-off period once a decision has been taken, to make sure that people can come forward and say, no, they either object or what, but within a certain period. I mean, just to also highlight the importance of the decisions that are taken to make sure that they are fair before we even take these decisions to court.
I would imagine that people who want to do business with various government departments and state entities would know, for example, who the people are who are likely to decide a tender. Am I right? In other words, maybe let me put it this way. A bid adjudication committee, that's the committee that makes the decision, is that right?
Yes.
Now, in regard to departments, a government department, would there be one bid adjudication committee for the entire department in different provinces, or would there be one for a particular province and a particular province in the same department? What is the position?
Okay. No, thank you, Chair. Currently, every department has its own bid adjudication committee. And whether you are in a province or you are at a national. But that's why in our prescripts we say those committees must be cross-functional. So that's one part that we're prescribing. But what is important to note is that your BEC, the evaluation committee, is always a non-standing committee, because it depends on the type of commodity that we are procuring. Then you put together that committee to come in. So it's not a standing committee. But your BAC, in many instances, are standing kind of committees where they know that, at a certain point in time, they need to sit as a committee, and the Secretariat must present recommendations of BEC on whatever procurement, and they need to make decisions on those so it's more similar to what we used to have in the State Tender Board, because the board was a standing committee with at least 6 members from the public representing different sectors, and then 6 government officials. So you had that combination, that mix during the Tender Board. But this current system, given accountability, we can't draw from people from outside unless maybe we review the legislation if we are to deal with this issue, to make sure that at least you bring in external people to be part of the bid adjudication committee to deal with transparency and any potential abuse of the system.
So what you are telling me seems to suggest to me that the answer to my question is that yes, indeed, if I know that there is going to be a tender coming up in a particular department that I'm interested in, I would or could know who will decide it, because the bid adjudication committee is usually or all the time a standing committee. So I would know that. If I want to know, I can find out.
Yes,
Yes.
that's correct.
And members of a bid adjudication committee, I assume, are employees stroke officials employed by the same department. Is that right?
Yes, is correct, but nothing prevents accounting officers from drawing from other departments.
Oh, okay.
Yeah, some
Okay.
people who must just come in,
Yes.
they either observe the process
Yes.
or provide technical support,
Yes.
but those, of course, are precluded from taking part in final decision making if they are observers. But if they are appointed as members, a different case altogether, because then they do participate in the final decision making, or even making a recommendation to the accounting officer, depending on delegated powers.
And who decides on the composition of a bid adjudication committee in a department? Is it the accounting officer, DG, or is it somebody else? It is the accounting officer.
Yeah, in a department, the accounting officer decides
Yes.
who should be appointed to that committee.
Yes.
Yes.
In a business entity, a state entity, do you know how it would work?
In a state entity, those that have got boards, the boards would decide.
Okay.
The boards would decide who should take part in that committee.
Yeah.
But in those public entities which are linked to departments, for instance, your 3A, because with 3A are your national public entities linked
When
to
you say
departments.
3A, you mean
To the
section
PFMA.
3A to the PFMA?
Yeah, the schedule 3A to the
Yeah.
PFMA. Because those entities are linked to specific departments. And therefore, the accounting officer there is the CEO, not necessarily
Yeah.
the board, because there is no board. I mean, you've got a number of them, similar of them. We can talk about quite a few of them that are such. And of course, 3Cs, that are listed as 3Cs. These are your public entities linked to provincial departments. So then you also have the CEOs, who are accounting officers who decide what should happen. The mother department simply, of course, as a shareholder, play an oversight role. But at the end of the day, the CEO, as an accounting officer, makes a decision. In a department, the DG makes a decision. In public entities, there's big SOCs and Schedule 2s and other public entities, the similar public entities. The boards do make decision who sits. Constitutional institutions, the CEOs again make that decision.
And is there legislation or policy that sets out what criteria must be applied in selecting individuals who would sit in bid adjudication committees?
Thank you, Chair. I think apart from prescribing that in all these committees, at least there must be a supply chain, a practitioner, and also in certain instances, the CFO of those departments must be part of this. There is no particular criteria of selecting individuals or officials that must constitute a committee. But at least we do prescribe that now, because this is the role of the supply chain management practitioner, is to make sure that the processes are applied and followed during the evaluation up to the adjudication process. That's the requirement, at least in the CFOs. Of course, our prescript says all the SCM units must be under the auspices of the chief financial officers of respective departments.
So there would be nothing to suggest that an accounting officer, in looking for people to appoint to a bid adjudication committee, must look for people who are people of integrity and people who have, for example, legal qualifications to understand some of the things, and people who might just be known for impartiality, that kind of thing. There would be nothing that says they must look at that.
It is correct, Chairperson. There is nothing that would prescribe. Safe to say that those that participate, it's in our prescripts, we've stated, those that participate must be unscrupulous. Where there is a conflict of interest, they must disclose, declare, and recuse themselves from the processes. Because, so we're prescribing broad kind of ethical standards that are applicable. But as to identify which individual best fits that criteria, we don't have. But at least we do have a broader kind of characteristics of prescripts of what the committee should do.
And would there be any study that may have been done to your knowledge, by any government department, maybe even your office, to say, or that would identify where most of the tenders where there are allegations of corruption and so on, or that even get taken to court, where exactly problems seem to be? For example, is the problem at the specification stage? Is the problem at the adjudication stage? In other words, is one of the weaknesses that bid adjudication committees do not seem to have people who can do a proper job? Is there any study or anything that has been done to say where exactly do things go wrong in our procurement system? If we want to fix the system, where should we focus?
Thanks, Chair. We always rely on the reports of the AG, because the reports of the AG, in as much as they do not go to that level of detail as to saying where exactly are the issues, but at least it is a usable report to see where exactly the problems are. At a very macro level, without going into deeper details, looking at case by case to say, if you're taking a basket of cases and say, let's look at these cases and see exactly what could have gone wrong, we ourselves have not done that study. But it's something that we definitely could do, because some cases are reported, some cases are not reported. So maybe one can always, approach it in a phased manner to say, let's look at all cases of a certain amount that are reported and analyze exactly where the issues are. Because courts would in any event go into detail and say the problem is here, whether the problem is procedure, whether the problem is the manner in which the specifications were crafted, whether the problem is the biasness of the members of the committees. The courts are able to give us that stats, but it's something that we can always look at, but we haven't done that studies yet, save for relying on what the AG says all the time.
Well, I can say that before this commission finishes its job, whether it's through your office or through the investigation team of the commission, I'll be very interested in something that tells us where the problem areas are in terms of procurement. Therefore, if we are looking at making recommendations, which are the areas that really need to be looked at? So it may well be that you might wish to go and reflect on this and see whether it's not something that, irrespective of this commission, whether it's not something that Treasury or your office, the whole government should look at and say, we have so many problems about tenders and procurement. Where are the problem areas? So that then there can be a focus in saying, this is where we must solve the problems. Because, for example, if 80% of the problems are with regard to the actual adjudication, it may be that more focus should be on that. But if 80% of the problems appear to be prior to that, then that can be looked at. Obviously, the whole thing must also be looked at, but the difference might be where you focus and where your emphasis is going to be, because your solution must seek to resolve the areas that present the most problems. Now, let me also ask you this. I don't know a lot about procurement, so if I ask some of the questions that reflect my ignorance, you'll forgive me.
Thanks.
You know, my observation is that when one talks, or let me start by saying, bid adjudication committees, they make decisions where there are competing interests. Different bidders say, here is what I would do, here is what I would do, blah, 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 and they make a decision. And one party wins, another one loses. Now, courts do the same thing. You know, it's not exactly the same, but they also decide where there are competing interests. They decide. Organizations such as the CCMA also decides where there are competing, there are disputes, you know. But my observation is that in this country, we don't have any significant problem of the public complaining that, for example, courts or even organizations such as the CCMA, they decide cases based on corruption, that judges, magistrates are bribed, that arbitrators in CCMA, in fact, a lot of bargaining councils throughout the country have got arbitrators who arbitrate disputes. I don't think we have problems of complaints, really, of people saying, well, I lost because the arbitrator or the magistrate or the judge was bribed, you know, that there was corruption. you know. So when I look at that, I look at how much different it seems to be with the adjudication of tenders. So I ask the question whether it might have, among other things, to do with the openness in which courts and organizations such as the CCMA make their decisions. Okay. They come and sit, it's open, it's public, anybody can come in and listen, and the decision is announced, it's known who decided it, they give reasons. Now, the adjudication committees don't do that. They do all of these things behind closed doors. And, the public won't know who made those decisions unless maybe there's litigation and so on. So I wonder whether it's too simplistic to say maybe if bid adjudication committees were to operate more openly, if, for example, the public is going to know that on that day, the bid adjudication committee of Department A will be sitting to consider and decide a particular tender. It's known where they sit, the doors are open, the members of the public can come and sit and listen, and the people who make decisions know that the public knows that they are the ones who made those decisions. The media can come in. Maybe that could contribute, but as I say, I don't know much about procurement. You know quite a lot. Have you got some comments that you can make on that? I know that there may be situations where a particular bidder might say, well, there is some sensitive information relating to my business that's involved there. But I don't know whether all bids would have that, and secondly, whether even if there is such a situation, whether it should prevail over the public interest that may be there in having that kind of openness and transparency, where those who make decisions know that I will be known publicly to be the one who gave that tender to so and so. If there's something wrong, everyone will know. If there are suspicions of corruption, they'll associate me with those suspicions.
Thank you, Chairperson. I think it's an invaluable proposition. Because procurement by its very nature is supposed to be an overt kind of process. That's one. But once one submits their responses or their tenders for adjudication, those tenders then become public documents. That is why whenever people want access to the winning bidders because they're losing, we have no objection, provided we disclose that information. So that could be done. I think if one talks about the big projects, because I think that's where you need to start, yeah, your big projects, that's doable. It's something that we can consider to kind of infuse in our own processes and see if we can't do that and see what the level of the complaints that we have, even the court challenges, cannot reduce, and something that we can consider. And obviously it has to be done, in my view, in a phased approach. but also having done some kind of study in terms of how many transactions go through quotations and how many transactions go through open competitive bidding process. Because some of these tenders are parceled. So in other words, they're broken down into smaller chunks, maybe to circumvent opening it up. Yeah. But it's something that we definitely can take home and see how we can practically apply it and roll it out. Of course, we need to pilot it somewhere and roll it out throughout the whole government. I know from a transversal point of view, because those bids are adjudicated centrally within the Treasury, perhaps that should be the starting point and see these are the tenders that Treasury is responsible for. Can't we open them up and then take that model, roll it out to government to see how practical it could be, given the number of tenders that are always in the system at any given time. But it's something that we can always consider.
No, and then you 2 times you mentioned something about accountability when you were referring to bringing in outsiders. If I understood you correctly, you seemed to think that if you bring in outsiders to participate in decision making, as opposed to giving advice, there would be a problem with accountability. If that is so, can you explain that to me?
Yeah. Thank you, Chair. That's correct, that's my thinking. In fact, if you look at the previous regime under the State Tender Board, where we had, as indicated, 6 members who represented different sectors of the economy, who were members of the board, and then you had 6 government officials who also represented different interests of different government departments, who would come in as a board and adjudicate on tenders. Now, when the decisions of the board were challenged, the departments would always say, no, but I mean, we didn't take these decisions. We did not take these decisions. So we can't be held responsible for these decisions because that decision-making power has been delegated to the board. So that is why the State Tender Board over and over had always been drawn into court, to kind of respond to their decisions. That's one. Now, when we introduced SCM, we were very clear in our own minds that if you bring in external people to form part of this bid adjudication committee, equally so, the accounting officer could simply say, no, but I mean, these people, when there is wrongdoing in that process, you can't take an action against them. So you can't discipline them because these are external people. But when these are officials of a particular department and there is wrongdoing in terms of what they do, then you have all the powers to hold them before a disciplinary action and take an action against them. So this is where we kind of coming in. Why are we saying so? Because the PFMA, by its very nature, its preamble talks to let managers manage and also account. If there is wrongdoing, there are so many other structures where they need to account to, from the DG, the accounting officers, right up to Parliament. You take disciplinary actions against them. But if they're external, people can always, run away without them being subjected to a disciplinary action. At least in this case, you're applying the public service regulations to take disciplinary action in terms of. So this is where the thinking was at the time. And I think until perhaps we get inputs from the public in terms of how do they view it, in terms of the new envisaged bill, it's something that we can look at and see how then do we make even these external people accountable. What do we do to make them account to decisions that they take as part of the collective on the bid adjudication committee? This is, in a nutshell, what I was explaining, Chairperson.
Well, it ties in with the question that I was going to ask you. You did talk about one, maybe two challenges that were identified with regard to tender boards, and hence they were abolished. I would like you to talk more about that. But before you do that, let me go back to what you have just said. You see, I have some difficulty with the proposition that says, let's not bring in outsiders
Okay.
to the bid adjudication committee, because then there will be no accountability. Obviously, it might mean that you are not going to be able to take disciplinary action against outsiders, but that doesn't mean there won't be accountability. There could well be accountability of another kind. And obviously legislation that would allow the use of outsiders would look at that.
Okay.
For example, if you are going to bring in a lawyer, an attorney or advocate, or you are going to bring in an accountant, an auditor, people who fall into certain professions, if you bring them in, you can rest assured that if there's something wrong that they have done in the adjudication that, for example, goes to issues of integrity, you can rest assured that there is a place where they could be reported and there could be action against them. So I wouldn't think that you would need to be concerned about accountability in the case of people like that, just because they are outsiders. But I don't know also, even in terms of members of the bid adjudication committee that are employees or officials of the department. I don't know if you know how much action is taken against them. Generally speaking, how effective is any disciplinary action that is taken against them? Do you have any ideas whether action is generally taken regularly and effectively? Do you know anything? All I know is from time to time one reads in the newspapers that within government, within the public service, at any given time, there are many employees and officials who have been on suspension, on full pay for a long time.
Thank you, Chairperson. Thank you very much. I think you are correct. That is why, although not in the similar context as you've just explained, the whole bid committee system is premised on cross-functionality. So in other words, you bring in all skills in that committee to be part of that process. It's premised on that process. You have technical people, you've got specific professions, and all of these people must sit in a cross-functional team so that there is joint decision-making. But our approach obviously has always been draw from internally, even if it means draw internally as in government. But we've always, I think, maintained that position that insofar as external people are concerned, we were a little bit very cautious. But it's something to look at and explore and make sure that if we do go that route, assumably, then that's something that we can look at in the new legislative review that we are busy with.
And then let's go back to the tender board. What was wrong with how the tender board was working?
The boards, firstly, maybe even before coming to what was wrong with the board, we had two conflicting pieces of legislation at a time. One being the PFMA, and then the state tender board. So now the PFMA surely was consistent with the Constitution, and the State Tender Board Act was inconsistent. Earlier on, I highlighted the fact that in the State Tender Board, you would restrict a person indefinitely from doing business with government. So these were some of the processes that even if you would try and amend that particular act, you would find difficulty in looking at this whole act and making it consistent with the Constitution. That's one thing. So the board itself, therefore, operated within a legislation that was inconsistent with the Constitution. That's the first thing. The second thing was the slowness within which services were delivered. Because as far as Uppington, Alexandra Bay in the Northern Cape, as far as Musina in Limpopo, Cape Town and so on, these decisions were taken centrally at the Treasury. And the pace was quite slow because all these submissions had to be brought to the State Tender Board, and the board would sit and adjudicate, at times approve, at times not approve. So when they don't approve, then it means the service delivery was affected at the time. So that was one of the considerations to say perhaps the system is a little bit outdated, and we needed a new framework that would make sure that accounting officers and authorities take decisions faster and for faster service delivery. That was the decision. Hence, the board then itself was disbanded in 2008. But of course, we phased the board out gradually, right from 2003, when we introduced this new framework, the supply chain management. Then we were phasing the board. But of course, contracts that were concluded against the State Tender Board were allowed to run their course. But as they expire, most of the tenders that we had centrally within Treasury, we decentralized. Took these tenders because they either ad hoc, in the sense that they are department specific, or in the sense that they were once off. And those that were transversal in nature and strategic to contributing to the economy, we retained. And that is what we are currently facilitating within the National Treasury. But even that system of the transversal bid adjudication is based on, is constituted by officials from various departments that come in and sit and look at this thing. It's not Treasury itself. Treasury's role is simply to facilitate, but these members are, of course, part of that process and delegated by their accounting officers and authorities in terms of Section 44 and 56, respectively, of the PFMA. Then they come and then they take those decisions on behalf of their respective departments. And then the management thereof, of these contracts, then results with accounting officers. All we do, we look at the administrative part thereof within Treasury. When is the contract expiring? What is the interval for price adjustments? What are the performance of the suppliers? And we take action where there is this lack of performance, and where there are allegations of fraud and corruption. We also make sure that we take decisions against such infractions. But this is how then the board operated at that time.
Did it move throughout, did it deal with all tenders throughout the country, same people?
In the main, chairperson, yes. But you may recall that when the new dispensation after 1994 came into being, there were provincial tender boards. But those boards, of course, were operating within the state tender board kind of setup. So that is why when the state tender board itself was disbanded, so were these provincial tender boards. But in the main, the state tender board was responsible for the entire procurement in the country. So these tenders were centralized within the state tender board.
I'm just thinking that when it comes to corruption and bribery in regard to tenders, logic suggests that people who want to bribe, who want to secure certain tenders, would actually want to bribe the actual decision makers, not somebody else. Maybe if they want to bribe somebody else, it might be because they want that person to reach a decision maker or the decision maker or one of the decision makers. Now, if you don't know who is going to decide your bid, then obviously you can't bribe somebody you don't know. Now, again, I must repeat that I don't know much about procurement, but with your experience, what do you think the chances are that corruption might be reduced significantly or to some extent if the identity of the person or persons who will adjudicate a tender is kept secret until almost the last minute? To what extent do you think that could help reduce corruption? In terms of mechanism, how you achieve that, we can talk about that, but just in principle.
It's a difficult one, Chair. The position always has been that because this is that's what we would have loved to believe, that if you constitute a committee cross-functionally, it's very difficult to go and bribe all these people. It's quite difficult.
But of course, if you know them, you might know that a particular one is very influential in the committee. If you get him or her, you might be halfway there.
No, I think it's important. I would agree with you that if you keep even the composition of those committees secret.
Yes, that's what I'm talking
Confidential.
about, yes.
Yeah, the composition confidential, and until the last day of the adjudication, it definitely would help to some degree to reduce the level of corruption.
As I say, how it would be done might be something else, how to achieve that. But let me put this to you and see what you might wish to say. What if in a national government department we had a panel of people, a certain number, let me say for argument's sake, 100 people that we put on a panel, and we say, these people have got mostly the kind of experiences and skills and information and knowledge that we normally need when we need to put together a bid adjudication committee. You know, out of these people, most of them, you know, would have what we need. And we say, we are satisfied that they are people of integrity. Okay. Now, if there is going to be a tender, and you don't know out of these 100 people, you might know that there are about 100 people, but, or even if you might know some names, but you don't know which 3 of these 100 or 200 or whatever could actually sit in your, in the particular tender, and maybe that is only known the day before the tender is adjudicated, or on the morning of the tender, and then they look at it and then they decide. Is that something that you think may need further reflection to explore? Is that something that appears to you to be quite impractical in terms of your knowledge? Is that something that may well help? And of course, you would have to be careful as to who puts together the committees. And there, you might say it's the accounting officer, but since the accounting officer is known outside, even to the people who are bidding, you might say, no, it should not be him or her. You might say, well, I will take, for argument's sake, a retired judge and say, we will tell you 2 days before the day when an adjudication committee must meet and decide a certain tender. Your job will just be to choose out of this panel any 3, and those must then go. Now, of course, if you say 2-3 days, there might be a problem about availability, so you might have to make it longer, but you might want to make sure that it's only that person who will know, or maybe, and those who are selected, who will know beforehand who is going to sit and decide that tender, and nobody else knows.
Chair, I think perhaps that's something to be explored. But sitting where I sit, I think one can always explore the possibility of having a retired judge presiding over some of these big transactions. That might help. But to the extent that we can identify certain individuals whose responsibility would, be to be members of the committee. I think that's something that needs further exploration. We can explore that and see what are the logistics thereof, what could work and what can't work. But given where we are in the challenges that we're facing, I think we need to explore all options, that are presented.
No, thank you very much. I think we have a duty. Certainly, I think that this commission has a duty to look at all possible ways in which the system of procurement can be protected from corruption. I guess there won't be a system that is corruption-proof completely, but we should do whatever we can to reduce the chances of corruption in any particular tender and to reduce the levels of corruption that the country has in relation to procurement. I don't have any further questions, and I must ask whether Ms. Kabashe has anything arising from the questions that I've put to you.
Thank you, Chairman. I think just 3 questions, really. The first relates to the reports that you make, be it to the Public Service Commission or whoever else. You indicated that you make recommendations in writing where there have been infractions. I beg your pardon, you said you make recommendations. So the question is, are these in writing? And you keep a record of each one you send through to whichever accounting authority?
It is correct, Chair. Some of these are in writing.
And you keep a record, so we would be able to get a schedule of those reports?
Yes, of the recommendations, Chair, thanks. That's correct.
Then the second issue, so again, a very brief one. What is the lifespan of a bid adjudication committee of each department?
Chair, it is not prescribed, how long they should be there. There is no term. I mean, that's the advantage of the system, because it provides flexibility to the accounting officer to decide when to rotate and to change members of the committees, especially bid adjudication committees. It allows them that space rather than the fixed term that the State Tender Board used to have, because it means if there is something during that process, then you stuck with that. But there is no term prescribed currently.
Well, but also what it means, I'm sorry, Mr. Bashe, what it means is that if a corrupt accounting officer wants to keep a wrong bid adjudication committee, he or she can keep them for a very long time.
Yeah, it's true.
Thank you, Chairman. And then my last question really relates again to the 3 committees you've referred to. The one was the bid specification committee, you've referred to the bid evaluation committee, and you've referred to the bid adjudication committee. Now, the chairman asked you about the vulnerabilities inherent in these committees and whether a more open system, such as a court system where the public are involved, or where there's less secrecy, I beg your pardon, where there is secrecy so that you only know at the very last minute who comprises that committee, whether that would be of assistance. That was really the tenor of the question. Would that proposition work for each one of these committees? It's one thing if there's only the final decision maker, the bid the bid adjudication committee. That might work well. But you did indicate earlier in your testimony that the bid specification committee can also formulate the specs in such a way as to favor a particular person. So would the same secrecy provisions have to be knitted into that level of adjudication? And then what about the bid evaluation committee? So we're really talking about 3 levels of decision making. Is this a practical way of trying to limit the opportunity for bribery, corruption, malfeasance? Thank you.
Thank you, Chair. Practically, it won't work for a bid specification committee, even for the bid evaluation committee, for the following reason. These 2 committees are not standing committees. They change all the time, because today I'm buying a table or furniture, school furniture, or then you put a committee just for the procurement of school furniture. The next day, you're buying textbooks, just an example. So it's a different committee. So that committee is not static. So both the evaluation committee and the specification committee are not static. But of course, your bid adjudication committee is always a standing committee. I think this proposition would work well there. But all I'm saying is, in as much as that proposition could work well there, at the back of our minds, there should be this thing that whenever the accounting officer approves the bid specification that eventually goes into the market, he or she has applied himself or herself to make sure that the specifications are correct and not biased, and so on. But when it comes to this transparent system that the chairs alluded to, I'm sure it could work well with the adjudication.
I think my last concern really with this is whether you would have the capacity. It always boils down to capacity. Capacity to put the right people in place, then the capacity to monitor that they are doing things in accordance with the rules of engagement or the prescripts. And that would really be the central challenge, I would like to think, at the end of the day.
Yeah.
But you might think of it as a short-term challenge, and if you really think it through properly, in the long term, you would resolve some of these systemic problems.
That's fine. Thank you, through you, Chair. I think this is one of our biggest challenge, capacity. That is why if you look at our system at the National Treasury, when we take interns, we take these graduates right from university and we put them through a system. And then they then get promoted through the processes. This is one way of building capacity. But it's very difficult to get ready-made material from the system. That's a challenge that we have, because we are a very small community, and yet our responsibility cuts across various institutions. So there is a capacity problem, both in terms of warm bodies, skilled warm bodies, as well as both in financial resources to make sure that we capacitate. But that's something that we're looking at now, as I indicated earlier on.
Thank you very much, Mr. Matebula. Thank you, Chairman.
Thank you very much. Just on that thought about a panel in regard to the bid adjudication committee, it may well be that if that kind of idea were to be looked into, it may well be that the panel from which people who would form a committee would need to be made up, that is the panel, made up of maybe partly internal people and partly external people. Which ones should be the majority, I don't know, but it might be that it's something that would have to be, the panel might have to consist of internal and external people to look at that. I know that I think you said at the moment legislation doesn't permit outside people to take part in decision making, but obviously if those who have the power were to be convinced, having explored that it's something worth looking at, obviously the question of changing legislation would be an option. Okay. Thank you. Oh, do you want to say anything in response before I excuse you?
Thanks, Chair. No, I think that's something that we need to look at in the review of the Treasury regulations framework to see whether we can't review that particular process. Because in my own experience, I've learned that law can't stop you from, we can change law at any time if you want to fit what you need, provided it is consistent, of course, with the Constitution. So it's something that one can always look at, because I'm just thinking that we have this prescript in the regulations. So as we review, it's something that we can explore and see how practicable it could be, but it is worth looking at.
Thank you very much, Mr. Mathebula. You must be quite tired. You have been on that seat for the whole day. Thank you very much. You have given us food for thought in terms of how procurement works. If we need you again, I have no doubt that you will remain available to us. Thank you very much. You are excused.
Thank you.
Mr. Pretorius.
Thank you, Chair. We had arranged or planned to ask Advocate Mokoena to open in relation to the next witnesses that are going to be called from Friday, but we would not want to break up his presentation, and as we're at 10 to 4, perhaps we should adjourn, and I should briefly tell you, Mr. Chairman, why the adjournment is necessary so that the public too can be informed.
Well, it depends on a number of things. As for me, if we need to stay beyond 4 o'clock up to like 4:30 for purposes of us finishing what you wanted to do today, I'm quite happy to do that. But there may or may not be a need for that if the witness that we have on next time we have a witness on Friday, if that witness, for example, is unlikely to finish anyway on Friday and might go on to Monday, therefore that opening could be done on Friday. But I'm quite easy also if we should come back tomorrow and do some work. I'm easy. Let me hear what you have in mind.
Let me, if you will, just consult. So tomorrow. Friday.
An alternative I can just mention before you respond, an alternative might be that on Friday we start a little earlier than 10 o'clock, maybe 9:30, to make space for that opening before the witness starts at 10.
That's the solution. Mr. McQuina and others have to consult with the witness at 4 o'clock, so that if we could adjourn till 9:30. In relation to the days in between, we, like the Commission as a whole, we as a legal team have also faced issues with witnesses who have been planned to be called over the next few days are no longer available, and we've had to postpone their testimony until next week, and that is the reason.
Okay, no, that's fine then. Very well. Let's then adjourn. So the proceedings are adjourned until 9:30 on Friday.
Thank you, Mr. Chair.
We adjourn.
All rise.